Hi folks, and welcome back to Contract Law. This is video 3 in the video series on remedies. And in video 1, we did a bit of an overview and started our discussion of damages. In video 2, we completed our discussion of damages. And now in video 3, we need to look at equitable remedies. Now, when you're looking at equitable remedies, there are some main things to remember. Firstly, you need to look to common law damages first. Equitable remedies won't be given if common law remedies are appropriate. So that's your first port of call. Also, being a creature of equity, equitable remedies are discretionary. So a court is going to have a good hard look at the conduct of both the plaintiff and the defendant, and all those lovely equitable maxims apply. For example, you have to come to a court of equity with clean hands. If you're asking equity to do something for you, then you need to make sure your own conduct is beyond reproach. First, equitable remedy, and probably most often sought, is specific performance. And specific performance is simply an order of the court to make one party perform an obligation. It's only going to be available, as I said before, where damages, common law damages in contract, are not appropriate. Generally speaking, this will be because the object of the contract is unique. That is, it's rare, it has particular sentiment for the plaintiff, and so on. It might be a land contract. Land is always considered to be unique because no one parcel of land is exactly the same as another. Normally, specific performance won't be applicable to agreements to lend money or agreements granting a license. Damages will be your remedy there. Also, it won't usually apply unless the requirement for mutuality is satisfied. What's that? Well, notionally, the order of specific performance has to be equally available to either party, both the plaintiff or the defendant. If it's lopsided and only one party could seek specific performance, for example, a contract with a minor where it's voidable at the option of the minor, you probably won't get specific performance in circumstances like that. Also, it won't apply to contracts for personal services because obviously employer-employee relationship, if you made one person employ another, or if you made one person work for another person, it's too much of an interference with your personal liberties. Also, if by ordering specific performance, the court would constantly have to march in and police the deal, break the parties up, so to speak, and supervise. It's not going to be something that the court is interested in. So they are just some general ground rules that you need to be aware of in terms of specific performance. The main case in this area is J.C. Williamson and Lucian Mulholland. And in that case, we had a lease of a theatre, and the lessees had agreed to allow a confectioner to exclusively sell ice cream, confectionaries and soft drink, yum yum. Unfortunately, the lessee repudiated the agreement, and the confectioners applied for an injunction, equitable damages and specific performance. In that case, it was held no, they could not get specific performance because the rights would require constant supervision by the court, and where that is required, equity won't march in there. What are some of your defences? Firstly, where the contract was entered into because of mistake or misrepresentation. Also, where enforcement would create undue hardship. Remember, this is a creature of equity, so they're not going to enforce one party to do something where it's going to create some kind of injustice. However, you can't just show financial hardship. That normally won't get you over the line. It has to be something fairly extreme, like undue influence. Where the plaintiff applying for specific performance is not ready, willing or able to perform themselves. Remember I said, again, this is a creature of equity, specific performance, so the court's going to look at the behaviour by the plaintiff. If they're not doing the right thing, they won't get the remedy. Also, one of the maxims is that equity won't do anything that's futile, and so if performance would be futile, equity will not order it. Also, if the plaintiff applying for specific performance is guilty of laches, delay. Again, one of the classic bars to equitable remedies, or if the contract is unenforceable itself due to some kind of informality where it was meant to be in writing, for example. So that is a very quick tour of specific performance. Injunctions, these are another equitable remedy. You can either get interlocutory injunctions, which are applied for right at the very beginning of a matter, sometimes ex parte, or just by one party urgently running off to court to try and preserve the status quo. Perhaps evidence might be destroyed, or the party might abscond, or something like this. Now, if that's the case, you can, as I said, run off to court and try and get an interlocutory injunction. There are three issues there. Firstly, damages must not be an adequate final remedy. The court has to be satisfied that there's a serious question to be tried, not a vexatious or frivolous action. And finally, the interim relief is justified on the balance of convenience. So you need to weigh up the inconvenience or damage to the plaintiff if no injunction was awarded, compared to the injury the defendant would suffer if the injunction was granted. To get a final injunction, you need to go to a hearing, and all parties have to be present and argue the case in full. Injunctions can be either negative, and they usually are negative injunctions. That means they prohibit a party from doing something. However, injunctions can also be positive, and we call these mandatory injunctions. These are more rare, but there's an interesting little use that a mandatory injunction has. You can actually apply for a mandatory injunction to force a party to perform only part of a contract. Whereas if you are asking for an order of specific performance, you will be asking for performance of the entire contract. So that's the little useful side to a mandatory injunction. Injunctions will not, and here are the limitations, be granted if there is no danger that the breach will continue. As I said, equity does nothing in vain. Equity does nothing futile. Also, an injunction won't be granted if it would essentially force a defendant to do something that they couldn't be ordered to do by way of specific performance. It has to be the kind of conduct that would be open to an order for specific performance. Have a look at page 1 records and written there. Equitable damages. Now, the text doesn't really go into this much, but I thought I'd mention it just for completeness. The assessment of equitable damages is something outside the common law and has really nothing to do with common law damages. Equitable damages are a matter for the court to weigh up in their own discretion. The power to award them is a power to enable the court to do complete justice as far as equity considers that it ought to be done, by supplementing with money some other equitable remedy, or attempting with money to substitute one of the other equitable remedies like specific performance or injunctions. So really, it's all about finding the most complete answer in the situation. Either you're using equitable damages to order some kind of compensation to one of the parties in addition to specific performance or injunctions, or in lieu of specific performance or injunction. And if you want to know more, I've provided a link there for you. It's a very good paper by the Honourable Justice Young there. Getting a bit old in the tooth, I guess about 20 odd years old, but a very clear extracurrial exposition on the nature of equitable damages. So that is damages in equity. Well, that was short and sweet, but I'll end this video here. So we have just the one video on equitable remedies, and we'll start our discussion of restitutionary remedies in video 4. So until then, bye for now, guys.